Today's date is August 25th, 2020. The court panel today is as you can see, Judge Carr. Good morning, Judge Carr. Judge Callahan. Good morning, Judge Callahan, and myself. And first case that we're going to hear today is John Bevelacqua versus Justin Tancak?
Tancak.
Tancak. Okay, thank you for that. Now, I notice that we have three attorneys for the appellee. It's my understanding that Attorney Yosowitz, you are going to consume 11 minutes of the 15-minute argument, and each of the other counsel will be speaking to us for 2 minutes. Is that what has been agreed upon?
I believe that's correct. Frank or Mel can correct me if I'm wrong.
That's correct.
All right, so that's the timeline we'll use. I'll try to, I may interrupt you just to let you know if you're at that 11-minute mark, so co-counsel will have an opportunity to present their argument as well. So I apologize ahead of time, Attorney Yosowitz, if that's the case. Each party has 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. And I'll let you know as well as you get close to that time. The arguments are recorded, posted on our YouTube channel, so we ask that you keep your voice up. I can assure you that Judge Carr, Judge Callahan, and I have read the briefs, and we are ready to proceed if you are. So let me just start off by asking the appellant, Attorney DeVito. Is he? Wait, Attorney DeVito is not with us, is he? Let's see.
He's observing as a participant, Your Honor. He's my co-counsel. I'm here on behalf of the appellant.
All right, that's right. I'm sorry. I'm sorry about that, Attorney Chamberlain. Let me ask you right up front here. Are you going to reserve some time, and I'll keep track of that for you?
3 minutes, please.
3 minutes. All right. With that, I think we're all set to go. So you may proceed, sir.
Thank you, distinguished members of the panel. May it please the court. My name is Hank Chamberlain. Along with Chris DeVito, we represent the estate of Sarah Bevelacqua. The issues before this honorable court today are, was Deputy Shaw entitled to immunity under 2744, and were his actions simply a negligence standard, and were they the proximate cause of her death? We maintain that the answer to that is no, he's not entitled to immunity. The second issue is, assuming arguendo, the court reaches an immunity issue, was Deputy Shaw on an emergency call which entitled him to immunity, and can a reasonable mind conclude that his actions were not reckless? We, again, believe that his actions were reckless, and that even if the immunity standard applies, that there was certainly a question of fact where the lower court decision should be reversed. Why is there no immunity in this case? Addressing the first issue. As this court is well aware, there's many decisions out of the 9th District and many districts throughout the Ohio. There's a 3-tiered analysis under 2744. Immunity applies in a general way. Then in the second tier, there's an exception to that immunity if an officer is negligent in the operation of a motor vehicle or one of their cruisers. They're responsible for the injuries or deaths that they may have caused. There's another exception on the third tier to that, where immunity then reapplies if they were responding to an emergency call at the time the injury happened. And if they respond to an emergency call and they cause an injury or a death, their actions have to be willful, wanton, or reckless in order to avoid the immunity. So the standard heightens. So emergency call becomes the key issue here. Was Deputy Shaw on an emergency call at the time Sarah Bevelacqua died? Emergency calls can happen in any situation. As this court is well aware, the case law is replete with circumstances that allow a police officer or a law enforcement officer to start an emergency call. And clearly that was done by Deputy Shaw when he saw 2 motorcycles and he turned in pursuit to apprehend them for speeding. It's important for this court to realize that the infraction involved with this motorcycle is speeding. So he starts the emergency call. Now, pursuant to an officer's authority, he can end that emergency call at any point in time. He can simply terminate it on his own judgment, or that emergency call can be terminated by others who are involved in the pursuit. In this particular case, at the intersection of 82 and 83, a senior deputy by the name of Trifoletti immediately observed that there was a passenger on the back of that motorcycle and it was going over 100 miles an hour, and he said, call it. Immediately after Trifoletti called that chase, Sergeant Perkins came onto the radio. Sergeant Perkins was the night shift supervisor who was the boss that evening, and said, terminate, terminate, terminate. That ends Deputy Shaw's call to duty. That ends the police chase. There is no provision, there is no rule or regulation that continues, that allows the deputy at that moment to be able to continue to pursue Justin Tancak on the motorcycle as he did. Again, the video speaks volumes, and we trust that every member of the court has had an opportunity to see that video. It's very important that you see the video. Shaw acknowledges the termination at 82 and 83. He shuts his lights and his sirens off, but he continues to pursue the motorcycle in violation of the order to terminate and in violation of policies and procedures. So where is the proof of his negligence after that point? Because we're no longer in an emergency call. It's been terminated.
Attorney Chamberlain, let me, because this is an important distinction or fact, I think. Did he continue to pursue, or did he just follow the vehicle? I think the other argument is that he followed the path of the motorcycle because he was concerned about whether or not there would be a crash, and given the fact that it was driving recklessly.
Thank you for that question. And that it is a matter of description, right? And in this, it becomes what will a reasonable mind conclude? And you need to watch the video. That video shows that Officer Shaw, after the termination, on a 50-mile-an-hour roadway, went 105 miles an hour for a mile and a half to Durkee Road. He exceeded the speed limit, more than double the speed limit, in pursuit of that motorcycle. And he catches up to that motorcycle at Durkee Road and brings his bumper literally right up to the back end of that motorcycle and intimidates it and unsafely spooks it, again, shoots out into the night, headed eastbound down 82 towards Route 57. That's
Counsel,
yes.
I have a question for you, because I feel very strongly that we need to stay with the evidence. Was there testimony from Mr. Tancak that he was spooked at that time?
Justin Tancak, conveniently, Your Honor, stated he had no memory of the entire evening. Despite a lack of a head injury at the scene of the collision, despite the lack of any type of head trauma, he testified in the criminal proceeding when he was brought up that he doesn't remember the entire evening. But
it is your perception or speculation that is, if I can, I'm not doing air quotes here, but to quote you, say that his lack of memory is convenient. Again, I'm just looking for what the evidence is here.
No question. And I appreciate your question. Thank you very much, Judge Callahan. It's not just my impression that this pursuit continued to aggravate the operation of the motorcycle. It was the conclusion of Lieutenant Ashdown. It was the conclusion of Chief Stamiti. It was the conclusion of Sergeant Kavanaugh. Every superior who had an opportunity to look at this video and judge it under their police guidelines, their standard operating procedures, their rules of conduct, said Shaw continued to pursue this this motorcycle and did not terminate as instructed.
I'm going to ask you one more question in that regard.
Sure.
Clearly, he was told to terminate. Am I correct in that he basically said he wasn't going to, or that he was going to continue to follow? Let me use those words. So I don't think there's any dispute that he said he was going to continue to follow, correct?
No, his quote, he came on the radio and quickly radioed after the termination. In a short one sentence, he said, I'm going to follow to make sure they don't crash.
Did anyone tell him not to?
No, Your Honor, there's no further communication on the radio after that.
Okay, thank you. Go ahead.
And that's,
Counsel,
Yes.
before you proceed, we all have questions here for you this morning. Is that a dispute of fact, though? Because wasn't there some testimony in deposition that the supervisor never heard him say that?
exactly.
Okay.
Exactly correct, Your Honor. Sergeant Perkins said, I never heard him radio it. Sergeant Perkins never understood that he was about to go 118 to 105 miles an hour down Route 82 to Durkee Road and continue to pull right up on the rear end of that motorcycle. He never would have allowed that. And that was the conclusion of Lieutenant Ashdown.
Okay, I'm sorry. I know it's just that we have limited time. So ordinarily I wouldn't try to interrupt you so much. So I apologize. But I want to make sure I understand something. Does the evidence demonstrate that after he was ordered to terminate the pursuit, that he still continued for 1.5 miles at 105 miles an hour?
100%. That's undisputed, Your Honor.
Okay.
Go ahead, I'm sorry.
No, after the termination, when there was no lights or a siren or anything, no indication of pursuit.
He proceeded for 1.56 miles at 118 to 105 miles an hour down Route 82 to Durkee Road. After Durkee Road, he proceeded at a rate on average of about 79 miles an hour in an area that was about a 45 to 50 mile an hour zone. There is a policy and procedure that if you are no longer on a emergency call, which he clearly was not, that no cruiser is allowed to proceed in excess of 15 miles an hour over a speed limit. Deputy Shaw doubled the speed limit and then never went below 25 miles an hour over the speed limit the entire time. When this crash concluded, and after everybody had a chance to look at the evidence in this case, everyone concluded that this emergency call was never terminated by Shaw. He continued to pursue. And that creates at least a question of fact on whether or not an emergency call was even in place at the time, justifying an immunity. We believe that this honorable court should reverse the lower court's motion for summary judgment and find that there's no immunity because there was no emergency call. It had been terminated. And termination is important. Termination needs to be followed because when a police officer, a superior officer, comes to the conclusion that the danger of that pursuit far outweighs the benefit of arresting a speeder, that termination saves lives. The statistics, which was brought out through the expert testimony, show that drivers return to normal operation once they perceive that they're no longer being pursued. We know that Tancak, or we have reasonable evidence that Tancak was still in the belief that he was being pursued because he shut his headlight off as he shot northbound on Route 57 in order to avoid detection by the police officer. You see at the very end of that video, he flashes his headlight on twice, still trying to stay invisible in the darkness, but he also has to determine the direction of the roadway. Shaw acknowledged in his testimony in the federal court hearing, his disciplinary hearing, after he was fired for this conduct, that he saw this headlight go on and off, go on and off. He knew that he was providing a presence that was aggravating that motorcycle. As soon as this crash happens, you'll see in the video, within a minute, within seconds, Deputy Shaw is right there. He is right on scene. He gets off, turns his, go ahead.
Well, again, counsel, as Judge Callahan indicated, did Deputy Shaw actually say that he knew that he was, that the motorcycle driver knew he was following him and he was egging him on? I mean, these are your perceptions and your conjectures with the evidence. Now, we just have to look at this at the summary judgment material. So did he testify to that effect?
Deputy Shaw never testified to the fact that he felt that the motorcycle was still being followed. It's a reasonable conclusion, Your Honor, from just a view of the evidence. And you can listen to the engines rev and the cars speed down the highway. It's it's almost an inescapable conclusion that for any reasonable mind who watches, and when I say reasonable minds, I'm talking about people like Lieutenant Ashdown, now Captain Ashdown. I'm talking about Sergeant Kavanaugh. I'm talking about the Chief Stamidi. All of these superiors to Deputy Shaw saw this evidence and concluded that he was pursuing and aggravating this chase. And that
Attorney
was why he
Chamberlain,
was fired.
I'm just going to interrupt you quickly because you're at 2 minutes and 20 seconds total. I don't know if you want to continue or, that includes your rebuttal time. So you're into your rebuttal time. It's up to you, but I wanted to let you know that.
Your Honor, if I'll take just a brief moment and I'll eat into my rebuttal time quickly. Even if we find that an emergency call is found, the factors that the court has to consider in this case are speeds, the use, non-use of lights and sirens, day or night, driver attitude, level of offense versus risk, reasonable alternatives, was the driver ID'd, policy violations, was an order violated, was there passengers involved, what were the internal charges and discipline that was involved. All of these factors exist here. Every one of them exists in this case. This matter, as a matter of fact, in Hardesty versus Alcantara, just a pursuit without lights and sirens. If you give them the benefit of an emergency call, that alone is a question of fact as to recklessness. So we urge the court for the following reasons. We request this court reverse the lower court's decision granting summary judgment, remand with an order that Shaw is not on an emergency call, no immunity applies. And even if arguably immunity applies, it's a question of fact as to whether or not his conduct was reckless, requiring reversal. Thank you very much.
All right, you'll have 1 minute and 23 seconds left for your rebuttal.
Thank you, Your Honor.
All right, Attorney Yasowitz, you're going to argue for 11 minutes, so you may proceed.
Thank you, Your Honor. May it please the court, my name is Andrew Yasowitz and I represent Deputy Adam Shaw. Your Honors, I first need to start with this concept of the emergency call. The emergency call issue has nothing to do with Deputy Shaw's immunity. The emergency call has to do with political subdivision immunity under 2744.02. Okay, so there's a difference between immunity for political subdivisions and immunity for employees of political subdivisions. Deputy Shaw is an employee of a political subdivision. His immunity is governed by 2744.03, more specifically 0.03A6B. So the emergency call is something that my colleagues, Frank Scaldone and Mel Luke, can address on behalf of the political subdivisions, but it doesn't impact Deputy Shaw's immunity. Deputy Shaw is immune as long as he did not act with malicious purpose, in bad faith, or in a wanton or reckless manner. Those all have different definitions. I'm going to focus on recklessness. It's the one that most often comes up. It's sort of the bottom of the spectrum for employee immunity under 2744.03. So what does recklessness means? It's conscious disregard or indifference to a known or obvious risk of harm to another that's unreasonable under the circumstances. It's consciousness that your conduct will in all probability result in injury. That's the definition used by the Supreme Court in Anderson versus City of Massillon, O'Toole versus Denahan, which this court summarized recently in another pursuit case called Anderson versus City of Westlake that was decided, I think, last November. So with that definition in mind, this case really is not a close one legally. The trial court correctly concluded that Deputy Shaw did not act recklessly.
Counsel,
Go ahead.
let me just interrupt you for a second. You gave the definition of recklessly. Do you agree that your client did continue to follow the motorcycle driver after the pursuit was called off?
Yes.
Okay. All right. So does the evidence substantiate that he didn't have any lights or siren or anything going and still followed him?
He did not have his
Okay.
lights and
right.
sirens active.
Okay. Now my question, I'm getting to the point. I'm sorry. So then what about the fact that does the record demonstrate that he did drive over 100 miles an hour after the pursuit was called off?
Only in the moments right after he turned off his lights and siren, he was still slowing down from the pursuit. What the evidence does. Oh, I can't hear you.
You're muted, Judge Carr. There you go.
It wasn't for a mile and a half?
I don't believe so. What I think, and what the evidence shows, and what the arbitrator who reviewed this case actually found, was that his speeds after he turned off his lights and sirens dropped by more than 40 miles per hour into the 70s. I don't dispute that he was still speeding, and I'm going to talk about that. And so, I mean,
Well, my point with that was, wouldn't that all be indicia of recklessness?
No.
Okay, why not?
I don't think so. I don't think so at all. So let's talk about what we're talking about, and what you're getting to, Judge Carr, is the post-pursuit actions. Okay, so after the pursuit is over, Deputy Trifoletti tells him to terminate the pursuit. Within 5 seconds, Deputy Shaw turns off his lights and sirens and begins slowing down. He's still going pretty fast, but he begins slowing down. Now, this court has indicated that it's reviewed the record. That record includes a dash cam. After Deputy Shaw terminates lights and sirens, he radios that, "I'm going to follow them to make sure they don't crash." And there's no objection from anybody on the radio. Sergeant Perkins, who has heard every other radio call during the pursuit, he testified didn't hear this radio call, but Deputy Shaw had no reason to believe he didn't hear that radio call. Deputy Trifoletti did hear the radio call. Deputy Trifoletti, who's the one that actually asked that the pursuit be terminated, had no objection. And so Shaw drops back, and if you watch this is one of those cases where it doesn't matter what the lawyers say, because it's all on video. If you watch the video, after he terminates the pursuit, he drops way back from Mr. Tancak's motorcycle. I mean, for a lot of the time, and I think we put a couple pictures in our brief, but for a lot of the time, the motorcycle is barely visible in the camera. I mean, he's far away from him. And besides, the other testimony is Deputy Shaw's going this direction anyways. He's near the end of his shift. It's almost 3 o'clock in the morning. Deputy Shaw's heading this way to go back to the sheriff's office. So let's talk about lights and sirens being off. If having lights and sirens on is a universal sign to motorists that you need to pull over, turning off your lights and sirens is a signal to the motorist that you're not being pursued. Deputy Shaw slows down significantly. He puts distance between himself and the motorcycle. The road conditions are the same as they were during the pursuit. It's a clear night. These are straight roads. There's really no other traffic on the roads. And following, this post-pursuit following is not prohibited by the departmental policy. I think this is a really important point because Mr. Chamberlain indicates, oh, he was brought up on disciplinary charges for, not terminating the pursuit. Well, there's a difference between allegations and findings. What's important is he was not found to have violated that policy. we've attached the arbitrator's opinion. What the arbitrator said was, it was somewhat common that deputies in that department would follow a vehicle after terminating the pursuit. That's in the arbitration transcript, which I think plaintiff filed. In fact, the chief deputy testified that if you follow at a safe distance and a safe speed, it's okay. And that's on pages 91 and 93 of the arbitration transcript. So yes, the supervisors alleged that he violated a policy, but that was not the finding of the arbitrator. That's one of the reasons he got his job back, because they didn't find that violation. So there's a difference between alleging violation of a policy and actually violating the policy. So that was not found. Moreover, even if he did violate the policy, in the Supreme Court and this court have said violation of a policy is not per se recklessness. The question that this court has is, well, based on Deputy Shaw's reduction in speed, putting distance between himself and the motorcycle, even if he was in violation of policy, is there some consciousness on the part of Deputy Shaw that that conduct would in all probability cause injury to Justin Tancak? That's the missing link. That's what's required for recklessness and what they don't have in this case.
Counsel, and that was something I was going to get at, so I'll just go ahead and ask you directly. What about from the standpoint that he did testify, and obviously there's disputed evidence, but he said that he called in and said, I'm going to nonetheless follow him. So, and he said, because I'm concerned he may get into a crash. So if he's concerned he may get into a crash and he continues to follow him, wouldn't that be maybe some evidence of recklessness?
I don't think so. I'm not quite sure what you're asking.
Well, you had indicated first that he had no idea, that the following of the motorcycle would be dangerous or reckless or anything like that, there was no evidence of that. And I said, well, wasn't there some evidence just due to the fact that he said, I'm concerned already that the motorcycle will crash, let alone with an officer following him?
So his concern was, look, I mean, when this started, you've got, 5 minutes before, the first time Deputy Shaw sees Tancak, he's basically drag racing another motorcycle. They're side by side and they zoom past him. So you got a guy, speeding, then he's not complying with an order or signal to stop. He makes some lane violations. Deputy Shaw has, I think, a legitimate belief that this guy's not driving very well and he might crash. This is a rural area. If he crashes, and there's nobody that's going to find them for minutes to hours. I mean, they're out in, I don't know Lorain County very well, but my understanding is this area of Lorain County is rural. So that's why he's behind him. But he, to allay any fear, I guess, that the motorcyclist would have, that's why he drops back. And that's why he's not, pursuing him. You can look at the difference between when he's pursuing him, lights and sirens, and after he turns off his lights and sirens. He drops way back. At the time of the accident, he's nowhere near the Justin Tancak.
Counsel, with that, your time is up if you're going to let the other attorneys speak here.
I will. I would ask you to affirm the decision of the trial court. Thank you.
All right, thank you very much. Who would like to go next?
This is Frank Scaldone on behalf of Lorain County. I can take my 2 minutes.
Very good, go ahead.
May it please the court, my name is Frank Scaldone and I represent Lorain County. We ask this court to affirm with regard to the county. Of course, the Political Subdivision Tort Liability Act provides broad immunity to political subdivisions. Here, again, we understand we're dealing with the exception for negligent operation of a vehicle that, and the important point is there's an exemption to that exception when there's an emergency call in the absence of an employee's willful or wanton conduct. I want to point that out to the co-defendant did a good job of explaining the conduct of the officer and how it was not recklessness, but I want to point out that the standard is willful and wanton. And those are extraordinarily high standards that the court must apply to demonstrate that the county is liable. Willful is intent to injure or harm someone, and wanton is exercising no care whatsoever. It simply does not apply under this set of facts. Plaintiff contests whether there was an emergency call. Emergency calls by statute and extensive case law indicate that it is interpreted very broadly. Essentially, an officer responding as part of his professional duties is a call to duty. Certainly, the initiation of a traffic stop in pursuit of a speeding motorist, here drag racing with a friend on a public road, blowing through major intersections, that certainly constitutes a professional obligation to address. Even importantly, even after the termination of a high-speed chase, that does not terminate a call to duty, and there's absolutely no case law that supports that proposition. Plaintiff, in a last-ditch effort to try and argue that point, presents some supplemental authority, Brown versus Cuyahoga Falls. Since I didn't have an opportunity to address that in the briefing, that is clearly distinguishable. The officers in Brown did not observe any illegal activity. They were not dispatched to the scene even of where the incident was occurring. They never even called into the station to say that they were responding to any kind of incident. And finally, one of the officers actually admitted he was not on an emergency call. So we believe firmly that the trial court correctly ruled here. I see that I'm getting dangerously close, if not exceeded.
You are actually up. Time is up. So
Okay, we ask this court to affirm with regard to the county. Thank you.
all right, thank you. I'm being a little generous with the time limits here because we want to hear from all of you. And
Appreciate that.
Attorney Luke, go ahead.
Thank you. May it please the court. Mel Lute on behalf of Columbia Township. I would join with my colleagues, Attorney Yasowitz and Attorney Scaldone, with respect to their arguments. Again, the Political Subdivision Tort Liability Act simply provides immunity under the circumstances to Columbia Township. The call to duty issue really isn't much of an issue because this officer, the testimony before this court, the testimony in the case is that he continued to follow after turning off his lights and siren out of concern as a law enforcement officer. He is exercising care. He is doing the things that are so far from the willful and wanton standard that, there's just really no question about it. And also that we have this video, as Attorney Yasowitz pointed out, which is critical because it really puts us in a position to see what was going on at the time and in real time. And that is so important when evaluating the activities of a law enforcement officer because their position is so unique in our society. They have to make these split-second decisions. They're out there doing the things that have to be done. And with respect to this particular case, Columbia Township would just request that the court affirm summary judgment in its favor. And with that, if the court has any questions, I'm happy to answer them. Otherwise, I'll relinquish the remainder of my time.
All right, thank you, Attorney Lute. Attorney Chamberlain, you have 123 left for rebuttal. You're on mute though, sir.
Hopefully that doesn't count. If I was on.
No, that doesn't count. Go ahead.
The trial court in this matter ignored all of the facts in favor of the appellant. This court has clearly outlined in the Callaway decision that a lower court has to consider all facts most favorable in non-moving parties' behalf and avoid, refrain from choosing among reasonable inferences and resolving questions of credibility in favor of the moving party. In this case, the lower court cited the deposition of Deputy Shaw and the testimony of Tancak. It ignored the video. It ignored the policies that were violated. It ignored the orders that were violated. It ignored the disciplinary proceeding. It ignored the findings of the supervisors, Lieutenant Ashdown, Stamiti, and Kavanaugh. It ignored the proximate cause evidence on the video of the lights flashing and the clear and unmistakable bolting that the motorcycle does in response to a cruiser behind it with no lights and sirens. It ignored the fact that Deputy Shaw went over 118 miles an hour down to 79, never within the speed limit the entire time his lights and sirens were off. It ignored the visibility issues, the speed issues, and the plaintiff's undisputed expert that came in to testify about the causation issues and the violations. Deputy Trifoletti, during the hearing, testified that when he first arrived on the scene, Shaw was upset. And he looked at him and he immediately said, "Did I do this? Did I do this?" Shaw asked Trifoletti that. It was the first question he asked. "Why would you think you did this if you were so safe and in such a distant, safely following from a distance?"
Attorney Chambliss, with that, your time is up, and I was a little generous with you as well.
Thank you very much, Your Honor. We ask for reversal of the trial court's motions for summary judgment.
All right, counsel, on behalf of Judge Carr and Judge Callahan, I want to thank you for the arguments. They're very good and the briefs are well written. So we'll take the matter under advisement, render a decision in due course. And of course, the decision will be mailed to you by the clerk as soon as it is released. And the opinions are also posted on Supreme Court of Ohio's website, as you know. But again, we want to thank you for your presentations here today and have a good day. It's a beautiful day outside. So thank you again.